lifelong resident, Your Honor. Two children. Indicates to us that he can stay with his father and will stay with his father. Self-employed, fixes our cars, and does home repair, Your Honor. He is on multiple medications for multiple issues. Right now, he's in the hospital, but if we can mark his file medical, it'd be greatly appreciated. Unfortunately, he'll be unable to afford any amount of bond, Your Honor. And I don't believe 100,000 is necessary, especially on both cases. Now, here's the kicker, Your Honor. Um, from what my client indicates to us, the complaining witness in this matter is actually the guardian, his guardian, and the conservator over his money. So she actually handles his medical and all his money goes to this person's account. Goes to this person's account. So basically, he's going to have to find some way to at least petition the probate court to get his money and to find a new guardian. I'm not saying aggravated stalking is correct. I'm not saying it's good. I'm not even saying he did it right at this point. But for argument purposes, Your Honor, you have somebody that has control over your body, understands that you have a mental condition, and took the responsibility to be the guardian over you, took the responsibility to take care of your money as conservator of that money. If what my client indicates to me is true, you can have conservatorship over your finances, and then after after I'm not sure. After you find out that it's almost like after you find out you got yourself into more than you expected, that you put a personal protection order out on somebody in which you still maintain the right to their finances and all their finances come into your bank account. I do see a problem with that, Your Honor. I do see a problem with that. Um, and respectfully, I would ask this court he could stay with his father. I asked him if his father could take over his guardianship and his conservatorship. He said his father can't will his father he indicates to me that his father is willing to do it. Now
Well,
I'm
let
not
me ask
sure
you
that
this, Mr. Byrd. Let me ask you this, Mr. Byrd. Is guardianship and with respect to the paperwork, is this a consensual, I mean, an agreement in terms of power of attorney, or was this court ordered? I lost Mr. Byrd. He said he would.
Oh, oh, oh.
Which case is this, John?
Page 2, 6, number 6 and 7. I'm waiting for Mr. Byrd either to log in or come inside the courtroom, so we'll see.
Where do you go? What happened?
Okay.
sorry about that, Your Honor.
No problem.
That's why I gave
You did warn me. You did warn me. All right, go ahead.
No, but I left off when you was asking me about guardianship.
Oh yeah, my question to you was this a voluntary situation where he knew his health issues and a power of attorney and the paperwork was done that way, or was this a court ordered guardianship?
Regardless if it's a court ordered guardianship, the person that's the guardian or conservator have to agree to being the guardian or conservator.
I understand that, Mr. Byrd, but I think there's a big difference in my mind, distinction between the two. I understand they have to agree.
And that I can't tell you, Your Honor. I'm not about to make up an answer for it, and I'm not even that well versed on probate. I have done it a little bit in my life when it comes to
Okay.
guardianships, but I wouldn't want to start answering questions just on probate matters.
Okay.
But the fact
Well,
about it is, this person has guardianship over his body and guardianship over.
yes, I get that. I get that. One last question, Mr. Bird. How long is it anticipated your client's going to be in the hospital?
I'm not sure. If Corporal McCree has or Mr. Garaneri has better answer, better guidance in that, it'd be appreciated.
Yeah, from my experience from coming down here very often, he should be out within about no more than 3 hours tops.
Okay. All right. Okay.
I mean,
all right.
I do. Sorry, Your Honor. Permission to speak.
Go ahead.
I do
Go
believe.
ahead.
I do believe that he needs help. He is on multiple medications for a variety of different issues.
I know. I know.
Which I'd rather not state. But being up under his father, being up under his father, and if we put a tether provision, I do think that would be the best recourse of action in this matter.
I would
Okay.
appreciate that, so I can get to my hospital appointments.
Okay. All right. The court haven't heard argument as to bond. Mr. Vincent was requesting $100,000 cash surety bond on both cases. And I am inclined to agree with him on this matter. I think the complaining witness is the same person in both cases. These are back-to-back instances within a matter of hours. And the fact that your client, Mr. Bird, has been previously convicted of aggravated stalking is further evidence to me that he is a danger to the complaining witness. And so for those reasons, I'm going to adopt the recommendation of the people with $100,000 cash surety bond on both cases.
Cash surety, what does that mean?
You have to have 100,000 to post bond. If not, they're going to send you to Wayne County Jail where you were sitting to trial.
So I don't have. I'm not getting.
You'd be going to Wayne County Jail.
I'm going to Wayne County Jail now.
With your attorney.
All right, and on the case ending in 5473, you've been fitted with if you're able to post that bond, your GPS to the house arrest. You cannot go back to the Pembroke address. You cannot have any contact with Catherine Webster. And you're not to possess any handguns, firearms, or other dangerous weapons.
Your Honor.
Wait.
You have any questions regarding your bond conditions and the court dates? Which I'm about to give you your court dates. I would advise you to make a statement. I would not advise you to make a statement.
And permission to speak.
Let me finish and I'll let you speak.
Sorry.
Bond redetermination will be January 27th, 9 a.m. in front of Chief Judge McConaughey on both matters. Probable cause February 3rd, preliminary exemption February 10th, both in front of Judge Jack K. Is there anything else either attorney wants to put on the record?
Yes, Your Honor. I'm just asking, would you even think about it? So maybe his father could bail him out and tether house arrest unless it's a medical appointment. I don't believe it's doing the system any justice to have a person with his conditions inside the confining jails and puts a stress on the jail. And I believe that a tether with house arrest, unless it's a medical appointment, it allow the courts and everything else to monitor his whereabouts. If he steps out that house, he's gonna go to jail. He's gonna go to jail. But a GPS tether with full home confinement, I think that would be the best thing for the system. It'd be the best recourse of action for the defendant with
Mr. Bird, I'd be inclined to agree with you if this wasn't back-to-back conduct within hours and he had not been previously convicted of aggravated stalking. And then the complaining witness, as I understand it, has a PPO against him.
It's the same witness.
I'm,
It's the same witness, Your Honor.
ma'am, sir.
And she
So
also,
I feel, okay, I'm going to say this, and then the matter is over with. I feel that he is a danger to her, regardless of the background circumstances, being guardian or whatever. Work it out, in court or whatever needs to be done. But this alleged behavior is unacceptable, and I am concerned about the safety of the complaining witness for the reasons I just stated. And so I believe he's a danger to her. And so those are the reasons why I'm giving a cash bond in both matters. Bond redetermination Monday, January 27th. Probable cause February 3rd. Preliminary examination February 2nd, and February 3rd is a probable cause hearing in front of Judge Jack Hay. All right, that concludes this. I'm sorry.
thank you for hearing me out, young.
Okay, that concludes this arraignment. Mr. Byrd, can we go on camera 4 to start?
I'm not sure.
Is that possible?
I'm not sure about that one, Your Honor. You have to call
Okay.
DDC and ask. Then if we do go on camera 4, I think it'll be best to ensure that the clients understand what we're saying.
I understand that as well, but I've logged into camera 4. Just let me know when you're ready finish with the interview so we can get started.
Okay, or you can call DDC and see if they got enough people. And I'm willing to get started whenever.
Listen. I think I know the answer to that already.
Okay.
All right. Talk to you in a few minutes.
No problem.
Thank you, Your Honor.
Morning. Probable cause has been found. Public defenders appointed. Let's begin the bail hearing with the state.
Your Honor, in this case, we're asking for $100,000 bail, bondable only. I would note that we spoke with the victim in this case. I believe he was on initially yesterday, although he does not want to appear and say anything today. He does want a no contact order though. He said he's very afraid of the defendant. So he does not know him for any reason, but again, is very concerned based on these facts. This is a very, very concerning case, obviously based on the facts. I would note, while it appears he's got no criminal history, it's because of his very young age and the fact that he just turned 18 back in October. But I would note that my information is that he is on juvenile probation, has a prior firearm offense as a juvenile. So extremely concerning in that regard. Also involved another juvenile in this case, and I think frankly, given the fact pattern of the fact that he fired and the bullet went through the shelving case and then lodged into the victim's leather jacket, frankly, lucky that it's not even more serious and possibly even a death, a murder type charge. So extremely concerning for this young man who has already had issues with firearms, involving other juveniles, extreme risk to the community in this case. And so we believe that that high bail is appropriate, as well as DAS supervision and no possession of firearms as well. I don't have any information about controlled substances or alcohol, but I would submit that given he's 18 and not legally able to consume either alcohol or marijuana or anything like that, that would still be appropriate in this case, given his age and the concern of anytime someone has substances on board, they're more likely to make bad decisions. So with that, I'd submit, Your Honor.
For the defense.
Thank you, Your Honor. We're going to ask for a OR release on some specific conditions. We're going to ask that Mr. Jones be required to comply with his juvenile court officer, that he be required to check in as often as his juvenile court officer would require. We'd ask him to be on house arrest only between the school and his aunt, Miss Pickett's home. It's my understanding in talking with Miss Pickett that Mr. Jones was a different kid before his dad died in 2021. That caused a huge disruption to his residence, his academic proceedings, and I can't tell you how many times I've heard about COVID, and I know that it affected everyone. But if you had a loss in the minute of it, there was no stability to be found in school either, and his housing had changed. For all those reasons, he really has struggled. I don't disagree with the state how concerning it is, and that his struggles don't allow him the freedom to hurt other people or frighten other people. My contention would be that can still be addressed. But when we have an 18-year-old, the best way of protecting the community and ensuring the compliance is to keep them with the officer. We were not able to meet with the officer or speak with the officer today. I do have Miss Cook, who is the chief of the youth defender team. She's scheduled to meet Monday with the juvenile courts, but wanted me to proceed today as that will control their decision-making. The services for teens are best addressed in that arena. I understand that this court has to be concerned about the community, but part of that is using the most resources, and the most resources there are through the juvenile, youth defender program. Last thing I would say is he does have a place to go. He does have people to go with. House arrest with electronic monitoring is not no penalty, and it's not no assurance of protection. Those exist for very real reasons, including protection. Taken totally, I would ask that this court release him OR with that house arrest and compliance in totality with his juvenile court. And on that, I submit.
So there is no monetary bail in juvenile court. The determinations are made without that. And I can't imagine that someone who's already on juvenile supervision, who allegedly shoots someone in the chest with a real bullet, who frankly got extremely lucky that this isn't a murder case because the bullet passed through the case and lodged in the person's jacket and only resulted in a bruise on their chest. Can't imagine that the juvenile court would think this is someone appropriate for release. And in this case, I think that due to risk to the community, there's extensive documentation, there's video evidence, there's an alleged confession. Another juvenile was allegedly involved by Mr. Jones. I think the risk to the community is severe. I have sympathy for what folks have been through always, but again, this was a hair's breadth away from being a murder case. And I think frankly, the $100,000 bondable is a gift. It'll be $100,000 bondable only, no contact with Vino's Market or the alleged victim, Harish Kumar. That's effective immediately. It's also pursuant to NRS 1784845 for 120 days. So if there's a violation, we'll be prosecuted for a separate offense. There'll be house arrest with the GPS location monitor before his release, no weapons and supervision by DAS. And yes, I think no drugs and alcohol clauses are appropriate legally. He's not allowed to use those things at this point. Thank you. Next, we have first appearance for Charlie Peterson.
I would ask to continue this one day.
All right, that's fine. You don't need to give a reason. We'll see Mr. Peterson tomorrow morning. It'll be me again.
And it's Ms., Your Honor.
Ms., that's right. I looked at her photo. Ms., that's right.
Sorry, Judge.
That's all right. Next, we have the last one is Robert Perzilba.
And he's waived his a parole hold. We would submit that hold has been in place and he has an extensive criminal history with 16 convictions.
All right, and this is an ad book allegation, so he's already in the jail. Probable cause is found, public defenders appointed. This is the matter where the Lux Travel was allegedly burglarized. What's the state's recommendation?
Your Honor, on this case, we're asking for an additional 15,000 above and beyond what was set yesterday. And
Right.
DAS revision if he gets
So
out.
$15,000 bondable only, no contact with Deluxe Travel, DAS supervision, no weapons. I assume other conditions may be already in place given his other cases. All right, counsel, that was all I show. Any questions or clarifications, or did I miss anybody?
No, and no from.
How we doing, DDC?
How we proceeding, Your Honor?
I'm going to start out with Echoes and then the Hill Brothers.
Lamar Evans.
All right, this is case number 250-554-7901. Houston, Michigan versus Lamar Echoes. Appearances, please. Mr. Vincent first.
Magistrate, good afternoon. Steve Benson, P71917.
Good afternoon, Your Honor. If it may please this most honorable court, Chester Jeunesse P 83295, representing Mr. Lamar Echoes, who's present and consents to this hearing via Zoom. Mr. Echoes, will you please state your name for the record?
Lamar Evans.
Reading stand mute.
Yes, we waive the formal reading of the information to stand, Your Honor.
Okay. There's a lot of background noise at DDC. Okay. Keep it quiet, please, so I can hear the attorneys. All right, the court will enter not guilty plea on behalf of your client, counsel. Mr. Vincent, your bond recommendation?
Magistrate, it appears as though the defendant's taken it seriously, has retained counsel. At this time, we're not going to be objecting to a personal bond.
Okay. $5,000 personal bond. You're not to possess any handguns, firearms, or other dangerous weapons. Probable cause February 3rd. Preliminary examination February 10th. Both in front of Judge Marlena Taylor. Is there anything else you want to put on the record, counsel?
Nothing from the people.
Nothing further, Your Honor.
Thank you. Step aside, Mr. Echoes.
Call me when you get out, Lamar. Thank you, Your Honor. Have a wonderful day, everyone.
Okay, you too. All right, I got both Hill brothers, Mr. Clements, Mr. Byrd. Oh, shoot. All right, this is People State of Michigan versus, this is case number 250-554-8401. People State of Michigan versus John Hill and Javante Hill. Appearances, please.
On both matters, Magistrate Stevenson, P 71917.
Yes, Your Honor. Brandon Bird on behalf of John Hill and Devontae Hill. I'm not sure we interviewed them quite yet, Your Honor.
You're not sure? You do, which one? What are you telling me?
If you give me a second to see, I don't have an interview for him.
Adam, are either of these guys yours?
One of them is.
No.
I'm representing Javante here.
I figured. Okay.
Yeah, we haven't interviewed the other one yet, Your Honor.
So what do you want me to do, Mr. Bird?
You could let Mr. Clemens arraign his client so he could at least get out of here. And as soon as we interview the other one, we get to you.
Okay, Javante Hill, state your name.
Javante Martinez here.
All right, appearances, please.
Regarding just this matter, Stevenson, P 71917.
May it please support, Your Honor. My name is Adam Clements. My P number is 77233. I'm here on behalf of Mr. Hill. Mr. Hill, we waived the formal reading of the information, asking he be allowed to stay in here, and the plea is not guilty to be entered on his behalf.
All right, the court is not guilty plea on behalf of your client by recommendation from the people.
Magistrate, as much as I can appreciate Mr. Clements be involved in this, we do feel as though this defendant poses a certain level of danger. He was just arraigned, I believe, by you about a week ago regarding a controlled substance matter. He was given a $50,000 personal on that case. And apparently that didn't stop him from allegedly committing this offense that has to do with controlled substances. In addition to that, at least what I saw in the CCH was that there's an open warrant request for another drug case. So Mr. Clements knows I have a lot of respect for him, but I have to do my part in terms of arguing the fact that this defendant is posing a danger. The people do feel as though he is. He had a bond condition, no drugs, and allegedly he's found with drugs this time around as well. So we're going to be asking for a cash bond. We're going to be asking for monitorization at the very least because he was on a personal bond at the time this offense occurred.
Mr. Clements?
I'm asking the court to set bond in the matter at $25,000 cash 30% with GPS settled. I don't really have much that I can say and push back to what Mr. Vincent indicated. My client was previously arraigned. He does have a pending matter, so this would be a violation of that condition. I would ask the court to consider this is a traffic stop circumstance where my client was a passenger in a vehicle. I believe that he has an absolute defense to these charges. Again, I haven't reviewed any discovery, but I do think that 25,000, 10% of federal is an appropriate amount.
I'd agree with that.
25,000 on 10%?
Yes.
And what did you say about the teller? You broke up on me.
I'm indifferent about the tether. I'll leave that to the court's discretion. I'm never going to ask for my clients to be on tether, but at the end of the day, I don't really have the strongest position on this case.
Okay, I'll leave it at $25,000, 10%.
Really good, John. Thank you.
And for defendant 2, I'll set a bond determination hearing for Monday in case he's unable to post. 9 a.m. in front of Chief Judge McConico. Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Giles. Okay?
Well, good, Your Honor. Thank you.
All right, thank you. DDC, can you bring back Eccles? Can you read Eccles file again? That's just for defendant two. You got Eccles file.
They have, he has a slave, it's split up, the slave right there.
What? For
The second, you're looking for the second defendant?
no, the case I did first, Eccles.
Eccles, yeah.
Okay, here you go.
Is John Hill getting it right today?
Yeah, they just have an interview there.
He's not on the list either.
He should be.
No, let's not overlook him.
No, he's on there.
Oh, yeah, he right above him.
Yeah.
Oh, Robert.
Yeah, he's supposed to be in the rank too, but I guess he don't have to determine.
No, he hasn't been interviewed yet.
Okay. Are you changing something on that file?
No, I just
I
forgot.
wanna make sure, you know.
All right, are you Mr. Eccles?
No, Mr. Jones, Eastside Jones, Eastside Rodney Jones.
Okay, Mr. Jones, Javon
Yes, sir.
Jones. All right, DC, can you bring out Lamar Eccles next when you get a chance? I just want to put some things on the record to make sure I got them right. All right, Mr. Jones, state your name for the record.
Eastside Rodney Jones.
What's your first name?
Deeson, D-E-S-O-N, Deeson.
All right, I got two Joneses. I got you confused with the other one. Bear with me. Yeah, I got the other Jones. All right. All right, this is case number 210-582-5401. Houston, Michigan versus Deshaun Jones. Appearances, please.
Thank you, Magistrate Stevenson, for the people.
Yes, Your Honor. Brandon Bird on behalf of Deeson Jones. My client waives his right to the formal reading, was advised his constitutional right, so we'll stand mute.
All right, the court will enter not guilty plea on behalf of Mr. Jones. Bond argument from the people.
Failure to pay, Judge, and I think it dates back from what I have is 2016. There's about 4,000 that's due and owed, at least at that point. If good cause can be shown, the people aren't going to be objecting to a personal.
Mr. Bird?
Your Honor, he was paying and then he went to prison. He's been home for about 5 months now, working on disability.
That's good. That's good cause. $2,000 personal bond. Probable cause in front of Judge Prentice Edwards, February 26th, in person, 9 a.m. at the criminal justice system. Step aside. Bring out Lamar Eccles, please.
February 26th. What was it? You said personal. Did y'all say personal bond?
$5 cash, 10%. Yes, personal bond.
Okay, the officer was asking, I was telling you.
I'm saying I just need Lamar Eccles. I need to put something back on the record.
I thought weekends were light dockets with like 6 or 8 cases. What's going on?
They were.
Yeah.
All right, Mr. Eccles, state your name.
Lamar Eccles.
Okay, I know you're Ryan, your attorney. Previously, and I just want to bring you back on the record because I'm not sure with the microphones and everything got caught or you heard everything. You were arraigned for a police officer assaulting, resisting, obstructing your attorney, waived the formal reading. You were given a $5,000 personal bond. Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Marlena Taylor. And while this case is pending, you're not possessing any handguns, firearms, or other dangerous weapons. Mr. Eccles, I know your counsel's here. I'm just reiterating what was stated earlier. Do you have any questions regarding your bond conditions and or court date?
Excuse me, I didn't hear you, sir.
Yeah, that's why I brought you back. So this very, very reason. I said I just wanted to repeat what was stated earlier. You got a $5,000 personal bond. You had your retained attorney, Mr. Jennings, and you're given the court dates of February 3rd and February 10th in front of Judge Marlena Taylor. You don't have to have any weapons. So like I said, I know I arranged you earlier. I brought you back because of the hearing issues. And did you have any questions because of your, any questions regarding your bond conditions and or court dates?
No, February 3rd and February 10th, correct?
Correct, yeah. Okay, yes, that's correct.
Okay, that's my court dates.
Okay. Those are your court dates. I just want to make sure you got them. I know people aren't hearing things well. That's why I wanted to bring you back out.
I got one question. Will I get some paperwork with the court? Will I get paperwork with the court dates on them? Or something in the mail?
Your attorney got your information, and you contact him. As a matter of fact, remember he said call him once you get out.
Right. Yeah, thanks, Your Honor.
Okay, step aside, please.
I mean,
That was pretty thorough.
Well, you know, I'm having hearing issues. They're having hearing issues, and you know, it is what it is. All right, sir. What's your name?
K1 Deshaun Lawrence.
What's your name?
K1 Deshaun Lawrence.
Lawrence?
Yes, sir.
All right. This is case number 250-554-6801, Peterson, Michigan versus Kawan Deshaun Lawrence. Appearances, please.
Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Kawan Lawrence. My client waives his right to the formal reading and will stand mute.
All right, the court will enter not guilty plea on behalf of Mr. Lawrence. Gentlemen, given the nature of the offense, ties, community, lack of criminal history, any objection to a personal bond?
None from the people.
No objection, Your Honor.
All right, sir, $5,000 personal bond while this case is pending. You're not to possess any handguns, firearms, or other dangerous weapons. Probable cause, February 3rd in front of Judge Kevin Robbins. Preliminary examination, February 10th in front of Judge Jefferson. Step aside, sir. I haven't had this many pages in a little while, Mr. Vincent.
It's crazy.
Abdul Rahman Al Said.
What's your name?
Abdul Rahman Al Said.
All right, this is case number 240-574-8301. Peterson, Michigan versus Abdul Rahman Saeed. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Abdul Rahman Saeed. My client waives his right to the formal reading and was advised his constitutional right to stand mute.
All right, the court will enter not guilty plea on behalf of the client. Bond recommendation from the people.
Magistrate, at this time, we're not going to be objecting to a personal. It's about 16 months old. The warrant was entered last May. I think you can see allegedly the defendant ends up altering his paper plate, and then when police do some investigation, he decides to pull off. They didn't pursue. I didn't find priors, so we're not going to be objecting at this time.
Yep, no objection to the personal bond, Your Honor.
$10,000 personal bond, probable cause February 3rd, preliminary examination February 10th, both in front of Judge Giles. Step aside. Okay, thank you.
Let's go.
Jalen Aaron News.
Repeat that.
Jalen Aaron News.
All right, Mr. Muse has two cases. They're both in capia status. One's a felony, one's a misdemeanor. It's calling case number 240-452-2301 and case number 250-550-2201. Cuba State, Michigan versus Jalen Muse. Appearances, please.
Regarding the misdemeanor matter, I don't know if this court, I don't think it has authority, but on the case ending in 5223, Steve Vincent for the people, P71917.
Yes, Your Honor. Brandon Bird on behalf of Jalen Muse, my client, waives his right to the formal readings and will stand mute.
Okay, the court will continue a not guilty plea on behalf of Mr. Muse. These are both capious bonds. I am not going to change them. They're set by Judge Jones and Judge Jefferson. The bonds will, for case ending in 5022, be $1,000 cash surety, 10% set by Judge Jefferson. And case number ending 522301, $1,500 cash surety bond set by Judge Jones. Bond redeterminations on both of them will be Monday, January 27th, 9 a.m. in front of Chief Judge McConaughey. For the retail fraud case, pretrial will be February 3rd. And for the resisting case, probable cause February 3rd, preliminary examination February 10th, both in front of Judge Jefferson. Is there anything else either counsel wants to put on the record?
No, thank you.
I would wonder if we could just change the bond. For the capious matter.
Okay, Mr. Bird, you broke up on me. Can you repeat, please?
I was just wondering, is there any way we could change the bond for Judge Jones to a personal? For that retail fraud, my client indicated to us that he didn't have any phone or transportation. We do have an updated number for my client.
Okay, you said he didn't have what now?
He didn't have a phone or transportation at that time. We do have an updated number for my client, updated information where we can stay in touch with him, and he indicates to us that he will appear for court.
Well, they're both cases for one for January 17th and January 23rd. So for both times, he didn't have a phone.
The 16th, 17th, and 18th, he had pneumonia. He was in Beaumont Hospital on Telegraph. His girlfriend sent proof to his attorney, but the court started and got. I know we can't change that bond, but if you want to know why he missed court on that matter, then that's the reason why he missed court on that matter.
Okay, that could be addressed on Monday at the bond redetermination hearing.
The capious was on
both cases.
The capious was on the 23rd. It wasn't on the 16th.
No,
17th.
he was asking about the other case for Judge Jefferson.
No, Judge.
I understand the case was on the 23rd, and that's why I said no transportation or phone was for the retail fraud. And when it came to Judge Jefferson's case, that's when he had the proof of pneumonia. But he was
that could be addressed on Monday. Mr. Muse, step aside. That concludes this matter.
So are we not changing retail frauds? You know, I mean, cases.
I am not changing it.
Gotcha.
All right, step aside, Mr. Muse.
Stay tuned. Marshall Kane.
All right, this is case number 240-450-7201. People said Michigan versus Samad Marshall Kane. Attention, please.
Thank you, Magistrate. Steve Vincent, P71917.
Yes, Your Honor. Brandon Bird on behalf of Samad Kane, my client waives his right to the formal reading, was advised his constitutional rights and will stand mute.
Okay, the court will hear a not guilty plea on behalf of your client. Bond recommendation from the people.
Magistrate, I understand it's a November 21st, 22nd incident date with a warrant entry of September 12th of 24. We are going to be asking for a tether, however. The incident was highly assaultive. There was an APA note by Gary Bresnahan in the notes where he said he was contacted by a prosecutor in Seattle, Washington. This defendant currently has a civil protection order against him by the complainant as a direct result of allegedly pictures where this defendant's showing guns, a multiplicity of guns. That civil protection order has been in place for quite some time, but the defendant hasn't shown up in Seattle for any of the hearings. He's been non-compliant. There is an order to surrender all of the guns. In addition to that, this is a DV second offense notice. So respectfully, at least through the pendency of this case, we're going to be asking for monitorization, not objecting to a person.
Bird?
No objection to the personal, Your Honor, but we're just asking for no tether in this matter. If Seattle, Washington wants to come and get my client, they have the ability and opportunity to do that. But for this matter, stems back from an incident in November of 2022. He's actually in the process of a divorce with the complaining witness. Indicates to us that he hasn't seen her since January 31st of 2023. We have been presented with no evidence in front of us that there's been any more complaints against the complaining witness in this matter, or that he had contact with the complaining witness in this matter. He understands there's going to be no contact, and doesn't matter. He hasn't been contacting him for the past year and a half anyway. But he just wondering 2 years now, actually, but he just wondering. He actually wanted permission to go out of the state to work. He's a truck driver. He's been doing that for 10 years now. And respectfully, we're going to ask this court for a personal bond and allow my client to work with no tether.
What's the status of the divorce case?
Let me see. What's the status of your divorce case?
It's not final yet. We have a court date coming up in about a month. Not exactly sure the date, but it's actually two. I filed for divorce here in June 2020, and she filed for divorce there in, I believe, August or July 2024.
What judge are you assigned to here?
Excuse me, I'm sorry, I couldn't hear you.
What judge are you assigned to here?
I can't remember, but it was a lady judge. I'm not sure. Sorry. I can't remember.
All right. In light of these allegations and potential volatility from a divorce proceedings, and notwithstanding the age of this case, I believe there is a potential for motions to run high in this matter. So I am going to give him $25,000 personal bond. He may leave the state for work, but I'm going to fit him in a GPS tether to make sure he has no contact with Lakeisha Kane. He cannot go back to the ward address. Does she live there? Or?
No, she does not. I live there. That's my home.
Right.
That's the
what I
mother of my
thought.
phone. So no, that's not.
Okay, I got it.
Sorry, sir. Just trying to make sure I'm clear.
Okay, I got it. I believe I just noticed he had another address.
Your Honor, my client.
Let me finish, Mr. Bird.
You be pausing sometime, and I'll be thinking.
Go ahead, Mr. Bird.
I don't want to interrupt you, Your Honor. Seriously, I apologize if I did. I could go after you say what you need to say, Your Honor.
Okay. $25,000 on a personal bond. You're not in possession of any handguns, firearms, or other dangerous weapons while the case is pending. No contact with Lakeisha Kane. I understand if you have to go to court together for for any divorce proceedings. That's an exception to that. That's court ordered. But I would advise you, if that does occur, you sit in opposite places, and there'll be deputies there. GPS tether, just to make sure you stay away from each other. Like I said, I think there's a potential for a volatile situation to erupt, notwithstanding the age of this case. Like I said, may lead the state for work. Probable cause February 4th. No, pretrial February 4th in front of Judge Garrett. Okay, go ahead, Mr. Byrd.
I understand when you say the volatility of the situation, but they've been going through these divorce proceedings. They've been going through these divorce proceedings for a while now, and my client hasn't had any contact with this complaining witness, or we haven't had any allegations of anything else against this complaining witness. So it's not like these divorce proceedings are new, and nothing's happened since those divorce proceedings been together. And nothing's happened since 2022 against that complaining witness, Your Honor. So when I understand when you say the divorce could be potentially volatile, and I can even understand if the divorce was just filed. And I believe that argument will hold a lot stronger. But as of right now, this divorce is finalized. That means that it's already been court dates on this matter. It's already been through a process already, in which my client has shown that he can stay away from the complaining witness and doesn't want to aggravate this situation even more.
Okay, let me tell you why I'm not changing my mind, Mr. Byrd, for two reasons. One, this is a second offense notice for domestic violence. And third, I don't know if you ever represented anybody in divorce matters.
I have.
Okay. You know how the vitriol and anger can be festering over an extended period of time, particularly if it's over assets and kids. And I'm not pretending to know anything, but just from my past experience, I know how intense and volatile and emotional ongoing divorce cases can get. In order to protect your client and potentially the complaining witness, I want a GPS tether to track that. And that's why I still think it's a potential for volatility. We may be, quote unquote, in remission right now, but particularly if it's an ongoing divorce matter, I just want to play on the safe side. Step aside, Mr. Kane.
We're ruining my client. He's not about to be able to work. We're ruining my client. When
Mr. Byrd, I have ruled. Step aside, Mr. Kane.
What was the ruling?
Can you give me one moment? Can I please get 1 moment, please, Your Honor?
1 moment for what?
I just need to talk to my law partner for a second and grab some more.
Certainly.
Thank you.
Okay.
Divine Edward Stewart.
All right, what's your name, sir?
Divine Edward Stewart.
This is case number 250-554-7001, People said Michigan versus Devon Edward Stewart. Appearances, please.
Thank you, Magistrate Steve Benson, P71917.
Yes, Your Honor. Brandon Byrd on behalf of Devon Stewart. Right to the formal reading and stands mute.
Okay, the court will enter not guilty plea on behalf of Mr. Stewart. Given the nature of the offense, ties, community, life, criminal history, and objection to a personal bond?
No objection to a personal, but I do want to just let you know, Judge, I think he had just gotten off of probation regarding a CCW as well as a felony firearm in July of last year.
Byrd?
Not sure what that means, but No objection, Your Honor.
$5,000 personal bond. Mr. Stewart, while this case is pending, you're not possessing any handguns, firearms, or other dangerous weapons. Probable cause, February 3rd in front of Judge Kevin Robbins. Preliminary examination, February 10th in front of Judge Jefferson. Step aside, please.
Yeah, been started.
Okay, did Moses jump on yet? Oh.
Javon Wesley Jones.
What's your name, sir?
Javon Wesley Jones.
Devon Jones?
Yes, sir.
This is case number 250-554-7101. Peace in Michigan versus Devon Jones. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Javon Jones. My client waives his right to the formal reading and will stand mute.
Court order not guilty plea on behalf of Mr. Jones. Again, given the nature of the offense, ties community, and lack of criminal history, any objection to a personal bond?
No objection on this.
No objection, Your Honor. EMT first responder in college, really trying to do good with his life.
$5,000 personal bond, sir, while this case is pending. You're not in possession of any handguns, firearms, other dangerous weapons. Probable cause, February 3rd in front of Judge Kevin Robbins. Preliminary examination, February 10th, both in front of Judge Taylor. Step aside, sir. $5,000 personal bond, Mr. Jones. Step aside. Good afternoon, Mr. Davis. How can I help you?
Good afternoon. I'm here on Mark Bowman.
Mark who?
Cordell Sherrod Putnam.
Okay, gentlemen at DDC, what's your name?
Cordell Sherrod Putnam.
Case number 250-554-7201, State of Michigan versus Cordell Sherrod Putman. Appearances, please.
Thank you, Magistrate. Steve Benson, P71917.
And yes, Magistrate, Brandon Bird on behalf of Cordell Putman. My client waives his right to the formal reading, was violates his constitutional rights, and will stand mute.
Court will not guilty plea on behalf of your client by recommendation from the people.
Magistrate, we're going to be asking for a 10,000 cash of surety with monitorization. It's the second offense notice. His first offense was that controlled substance delivery manufacturer. He got 1 to 20. Here, allegedly, he ends up having over 70 grams of fentanyl, over almost 50 grams of meth. And then we have his brother who's saying that this defendant prior to this incident sold him drugs at the same house where the defendant was found. Also hand-to-hand transactions that the defendant was found performing at the residence. We find him to be a danger. This is fentanyl. This is meth. Both are over 100 grams in total. So respectfully asking for that cash.
Mr. Bird?
Non-assaultive, Your Honor. Non-assaultive. 38-year-old lifelong resident indicates to us that he has one child, lives with family members, does landscaping, snow removal. Always vary on that matter, Your Honor. Respectfully, high blood pressure, but indicates to us that he's not on medication. His file can be marked medical. We appreciate it, but hopefully we can get him out of here on these non-assaultive allegations right now. And respectfully, we're gonna ask.
Does he have an alternative place to stay?
Mr. Putman, can you stay somewhere else besides the
Yes.
Yep.
I'm gonna give you a personal bond, sir, $10,000 personal bond with the following conditions. You're not to use nor possess any illegal drugs. You cannot go back to the Buckingham address where you live. Is that clear?
Yes, sir.
Okay, I'm not gonna put a tether on you, but that doesn't mean another judge may or may not. If you continue allegedly on this path. Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Giles. Step aside.
Well, we gotta call Mark Bowman next, Your Honor.
Give me one moment. Nobody's at the screen yet. Give me one moment.
Mark Nicholas.
What's your name?
Mark Nicholas Bowman. Mark Nicholas Bowman.
Slow down and say it slowly, please.
Mark Nicholas Bowman. B-O-W-M-A-N.
Thank you.
Go ahead.
All right, this is case number 250-554-1501, State of Michigan versus Mark Nicholas Bowman. Appearances, please.
Thank you, Magistrate. Good afternoon, Steve Vinson for the people, P 71917.
Good afternoon, Your Honor. I'm Maurice Davis, P 76203, appearing with Mark Bowman, who's present appearing in custody. Waiting for him to ring in and play with stand mute.
Court will or not guilty plea on behalf of your client. Mr. Vincent, bond recommendation from the people.
Magistrate, as you can see, it's a distribution case of unclothed persons being two different individuals that the defendant allegedly was having sex with, that he videotaped without their consent. I guess this got out as a direct result of him sending a hard drive over to somebody to edit something, and it had these two different movies of this defendant having sex with these two ladies unconsensually, not the sex, but so much as disseminating them and this defendant having sex. Judge, I don't know if I can make an argument before you that this defendant is a flight risk. I can appreciate the fact that Mr. Davis is involved in that, so he's taking it seriously. A danger, possibly, but I have one prior, but it was deferred under 7411. So respectfully at this time, I won't object to a personal bond and any conditions, Judge, you think are appropriate here.
Mr. Davis?
Yes, Your Honor. I've been retained on this matter for a few months. I talked to the detective. Thought the detective would let me know once charges were authorized. I wasn't aware my client's in custody, but he's not a flight risk. He's not going anywhere. He has retained counsel. He would have turned himself in had he known that there was a warrant outstanding. He's 32. He's an engineer. Just asking for a personal bond. I believe it's appropriate given the circumstances.
He's got an engineering degree?
Correct.
So where did he get his degree from?
I'm not sure where he got his degree, but I know he's working as an engineer.
Okay. All right, $50,000 personal bond. Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Taylor. Step aside, Mr. Bowman. Anything else, Mr. Davis, you want to put on the record?
No, nothing else.
Okay, thank you. Have a good day.
Thank you. You as well.
Woo! How are you on the interview with the other Mr. Hill, Mr. Byrd?
We're done with Mr. Hill.
Okay. I'm sorry, the echoes or whatever. Can you slow down and state your name?
My name is Eric Stephen O'Dreamy. Sir.
Okay. Eric, Oghenjan?
Yes, let's go.
All right, this is case number 2205778-001. People say Michigan versus Eric Ojan. Appearances, please.
Steve Benson for the people.
Yes, Brandon Bird on behalf of Eric Ojan. My client waives his right to the formal reading with advice his constitutional rights and will stand mute. I mean, actually, this is on a bench warrant. Sorry,
Yes, court will continue not guilty plea. This is a bench warrant set by Judge Jefferson for preliminary examination. She set the bond at $7,500, 10%. The court will continue that bond.
Magistrate, it's 5,000 cash as surety. The 7,500, 10% was the prior failure to appear. And then
I stand corrected.
Yeah.
I stand corrected. You are absolutely correct.
Okay.
$5,000 cash surety. I was looking at the wrong paper. That's the previous capias.
Is it?
Yes.
I'll update it to you.
No, I got it.
Okay.
I got it, no problem. $5,000 cash surety. Bond redetermination hearing, January 27th, 9 a.m. from the Chief Judge McConical. Probable cause February 3rd. Preliminary examination February 10th, both in front of Judge Jefferson. While his case is pending, sir, you're not to possess any drugs. Is that clear? All right. All right, it's connected.
John Hill. My man. My new goes right here.
All right, Mr. Hill. Case number 250-554-8401. Houston, Michigan versus John Hill. Appearances, please.
Thank you, Magistrate. Steve Benson, P71917.
Yes, Your Honor. Brandon Bird on behalf of John Hill. My client waives his right to the formal reading and will stand mute.
All right, the court will not guilty plea on behalf of this Mr. Hill. By recommendation from the people.
Magistrate, this is defendant one. He's being charged with the CCW, not the controlled substance. He doesn't have any open cases. At this time, I'm not going to be objecting to a personal.
No objection, Your Honor.
$5,000 personal bond, sir. While this case is pending, you're not to possess any handguns, firearms, or other dangerous weapons. Is that clear?
Yes, sir.
Oh, what was his court dates for the
February 3rd, February 10th. For the
February 3rd, February 10th? Probable cause, preliminary examination in front of Judge Giles. Step aside. Thank you.
You said my court date was when?
February 3rd, February 10th, both in front of Judge Giles. He shouldn't be in front of.
Who? Who's that?
It's a CCW. Shouldn't be in front of. Oh, I stand corrected. I think that should be probable cause January 30th from the Judge Kevin Robbins, and then I think no, the other one wasn't a gun case, drug case. John Hill is a probable cause.
Right, you have to sleeve for that one. It's in two separate things.
Oh,
That's
two
it over
separate
there.
things. Okay.
It's over there. Yeah.
Yeah.
Where's the sleeve?
That one going to say.
This one?
Yes, that's the second defendant. Or first, that John Hill?
This
Yeah,
is
John Hill is the one we just did. That's the first one. That should be going to.
No.
okay. I'm back.
But you got it right. You just said the wrong judge on the record. It should be Robbins.
So one is going, number two is going to, I guess, Giles.
Hey, good thing we caught it.
Yeah, that's true. That's true.
All right, what's your name? Slow down and restate your name. Dewan. What's your last name?
Williams, Philip, Dewan Williams.
Number 1 on page 3.
Okay. Just having a tough time hearing. Okay, this is case number 250-442-7301. Case of Michigan versus Philip Dewan Williams. Appearances, please.
Thank you, Magistrate. Steve Vincent for the people.
Yes, Your Honor. Brandon Bird on behalf of Philip Williams, my client, waives his right to the formal reading and will stand mute.
Court read a not guilty plea on behalf of Mr. Williams. Bond argument, Mr. Vincent.
Magistrate, I know you're familiar with the allegations, so as a result of the way it's being charged and the allegations, including the punching and slamming, we're not going to be objecting to a personal. We are going to be asking for monitorization. And I just want to direct your attention to the reason for that. The defendant ended up coming back to this residence subsequent to this alleged assault. Allegedly, he ends up fleeing, then only to come back. We think, based on the assault, there's a level of danger, but then based on him trying to get back into the residence when the complainant was there after she called the police the first time and then had to call the police a second time, we do feel as though monitorization is necessary. In terms of priors, Judge, I have a UTA juvenile adjudication in 12, and then I have a CCW HIDA in 15, as well as an RCSP motor vehicle HIDA as well. And that was HIDA, yeah.
Mr. Bird, address the issue of tether.
My client is not trying to run from this matter. He understands that he can't have any contact with the complaining witness and doesn't want to have any contact with the complaining witness at this point. Does heating and cooling for a living. Going into his client's houses with that tether would severely destroy his business. But I know that's not really too much of a consideration when it comes to the tether. But I don't believe him to be a flight risk or a threat to the complaining witness. Last case he had was 10 years old, Your Honor. So respectfully, we're just gonna ask for that personal bond and no tether. And he's still maintaining his innocence in that matter, Your Honor.
Do they still reside together, Mr. Byrd?
I have two different addresses. And it looks like, yeah, I have two different addresses, and they are apart some ways, Your Honor.
Any assault of criminal history, Mr. Vincent?
I didn't find
Did I
any,
miss any?
Judge. No, I didn't find any.
Okay. All right, $50,000 personal bond, Mr. Williams. I don't see a need at this time for this tether. Given your lack of prior assault of history. You're not possessing any handguns, firearms, or other dangerous weapons while this case is pending. No contact with Janelle Bailey. That means just that, no contact. No phone calls, text messages, emails, handwritten letters, or notes through social media to third party. You cannot go back to the cabin address. Is that clear, sir?
Yes, sir.
Pre-trial, February 4th, in front of Judge Garrett. Step aside.
My law partners are wondering, is there anybody available so we can do the interviews on the female sides, or did we want to just finish up the males and then go over to the female side? So we
The shift change, so they're trying to get somebody over there now.
All right.
Right. Okay. What's your name, sir?
Ariano Francesco Pasquaretti.
This is case number 250-554-7501. People say Michigan versus Mariano Francesco Pasquaretti. Appearances, please.
Thank you, Magistrate. Steve Vincent, P71917.
Yes, Your Honor. Brandon Bird on behalf of Mariano Pasquaretti. My client waives his right to the formal reading, was advised his constitutional rights, and will stay on mute.
We're not guilty plea on behalf of your client. Bond argument, Mr. Vincent.
Magistrate, serious but non-assaultive. I see it as the controlled sub twice over counts of less than 25 grams. Arguably, he's a danger, but only to himself. So respectfully, we're not going to object to a personal.
No objection, Your Honor.
$10,000 personal bond, sir. While this case is pending, you're not to possess nor use any illegal drugs. Is that clear, sir? $10,000 personal bond. While this case is pending, you're not to possess nor use any illegal drugs. Probable cause February 3rd. Preliminary examination February 10th. Both in front of Judge Jefferson. Step aside, please.
Yes, sir.
Your Honor, can I please have the date and the judge for
Judge for who?
For Philip Williams, please.
February 4th. February 4th.
Thank you.
What's your name, sir?
Okay.
So the microphone recording at DDC is very, very bad. Can you state your name again and say it very, very slowly? Okay, thank you.
Is that Peter Price, Your Honor?
Yes. It's just the microphones at DDC are just so bad. I can barely hear it.
And the client's ability to hear us is horrible too, Your Honor. We're off of camera 3. If you wanted to try camera 3 to see if it works better, it'd be appreciated.
Okay, I'll log in. Only because you requested, Mr. Bird.
Thank you.
Never said I didn't give you. Never said I didn't give you anything.
Rose.
Okay, Mr. Price. This is case number 250-554-7601. Peterson, Michigan versus Peter Danielle Price. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Peter Price. My client waives his right to the formal reading, was advised his constitutional rights, and will stand mute.
All right, the court will not guilty plea on behalf of Mr. Price. Bond recommendation, Mr. Vincent.
Magistrate, we're not going to be objecting to a personal. The defendant has no priors. It's non-assaultive. It is serious, but again, not objecting to a personal.
No objection, Your Honor.
$10,000 personal bond. While this case is pending, no drugs, sir. Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Marlena Taylor. All right, step aside.
You said February 10th, sir?
February 3rd and February 10th. Judge Taylor. All right, are we going to camera 3? I wish I could go back to the old days of camera 1 and 2.
Yeah, that would be nice.
One day. What's your name, sir?
Sorry, bro.
Okay. We're having some hearing issues. State your name very, very slowly.
Dakari Brown.
This is case number 250-554-7701. Peterson, Michigan versus Dakari Brown. Appearances, please.
Thank you, Magistrate. Steve Benson for the people.
Yes, Your Honor. Brandon Bird on behalf of Dakari Brown. My client waives his right to formal reading, was advised his constitutional rights, and will stand mute.
Court will not guilty plea on behalf of Mr. Brown. Bond recommendation from the people.
Magistrate, another drug case, 1 count, controlled substance, under 50, serious but non-assaultive. We're not going to object to a person.
No objection, Your Honor.
$10,000 personal bond, Mr. Brown. While this case is pending, you're not to possess any nor use any illegal drugs. Is that clear, sir?
Yes, sir.
Probable cause February 3rd, preliminary examination February 10th, both in front of Judge Giles. Step aside. All right, are we going to camera 3 anytime soon?
No, we can't. This is causing feedback.
Oh, I can't win today.
No, I appreciate it. I appreciate it, Your Honor. I because we do got to make sure that those clients hear what's going on too.
Yeah. And so that I'm able to hear them as well. You know,
yeah,
it works both ways.
It's ridiculous. Like we really need to get to camera 2 again.
Don't forget camera 1.
Yeah, but camera 1 we just can't interview on because that doesn't have that. I don't believe that has a door. That's where everybody. That's where all the officers are.
Oh, okay. All right, we're back to camera 3. All right, state your name, sir.
Troy Wells.
All right. This is case number 250-554-8001. Peterson, Michigan versus Tory Wells. Appearances, please.
Thank you, Magistrate. Steve Benson for the people. 71917.
Yes, Your Honor. Brandon Bird on behalf of Tory Wells. My client waives his right to the formal reading and will stand mute.
Court order not guilty plea on behalf of Mr. Wells.
No
objection. The nature of defense. No objection to personal bond.
No.
None, yeah.
$5,000 personal bond. Any objection, Mr. Bird?
Nope.
$5,000 personal bond, sir. While this case is pending, you're not in possession of any handguns, firearms, or other dangerous weapons. February 3rd, probable cause for the Judge Kevin Robbins. February 10th, preliminary examination for the Judge Giles. Step aside, sir.
All right.
Sorry, Magistrate, I just wanted you to save your voice there, that's all.
Oh, there's plenty more where they came from. But you're right. I have to save my voice from Mr. Bird's rebuttals.
Get ready.
What's your name, sir?
Marcel Coleman.
All right, Mr. Coleman. This is case number 250-554-8101. Houston, Michigan versus McQuavion Marcel Coleman. Appearances, please.
Steve Vincent for the people.
Yes, Your Honor. Brandon Bird on behalf of Quavion Coleman, my client waives his right to the formal reading and stand mute.
Court not guilty plea on behalf of Mr. Coleman. Any objection to personal bond in this matter?
No objection.
$5,000 personal bond, Mr. Coleman, while this case is pending. You're not to possess any handguns, firearms, or other dangerous weapons. Probable cause February 3rd in front of Judge Kevin Robbins. Preliminary examination February 10th in front of Judge Jefferson. Step aside, please.
Stand up.
What's your name?
David Christopher Sewell Senior.
All right, is Mr. Jenkins? Jenkins as well?
Jenkins.
Yes,
Mr. Jenkins.
All right, gentlemen, state your name.
David Christopher Sewell Senior. Zanovis Anthony Jenkins.
All right, this is case number. Case number 250-554-8201 and 02. Houston, Michigan versus David Sewell and Zanovis Jenkins. Appearances, please.
On both matters, Steve Vincent, P 71917.
On both matters, Your Honor, Brandon Bird on behalf of David Sewell and Zenobia Jenkins, my clients waive their right to the formal readings, revise their constitutional stand.
All right, the court will not guilty plea on behalf of both defendants. Bond recommendation from the people.
No objection to either. I have defendant 2, though, as being a HAB third offense notice, so I would just ask the court to take that into consideration when issuing a bond.
No objection, Your Honor.
$5,000 personal bond for both. Mr. Sewell, your probable cause February 3rd in front of Judge Robbins, preliminary examination February 10th in front of Judge Taylor. And Mr. Jenkins, you will have a probable cause February 3rd in front of Judge Taylor and a preliminary examination February 10th in front of Judge Taylor. Step aside, gentlemen.
Thank you.